Welcome to the deep dive. Today, we're getting into a really essential tension in contract law. It's this battle between, the strict black and white text of an agreement
Right.
and the implied ethical promise that kind of holds the whole system together.
Mm-hmm.
We're talking about conditions. Those critical terms that say, I will pay you X if and only if Y happens.
The trigger.
Exactly. But what happens when the person who owes the money, who owes X, decides to sabotage Y? I mean, they actively make sure the condition fails just to avoid paying?
And that's where the law has to step in. This concept of wrongful prevention forces us to look beyond the literal words on the page.
It forces us to examine the duty of good faith.
That's precisely our analytical mission today.
Yeah.
Contracts aren't just, technical manuals. They're meant to be cooperative. So we're going to analyze that core doctrine, the duty of good faith and fair dealing. It's so foundational. It's basically embedded in every single contract.
And we're going to see how a breach of that duty can legally excuse a condition precedent.
We will. And our framework for this is a perfect case out of the Arkansas Court of Appeals. Cantrell-Waind and Associates v. Guillaume Motorsports. It gives us a blueprint for spotting what is essentially deliberate contractual sabotage.
Okay, so before we get into the fascinating facts of that case, let's lay the doctrinal groundwork. Where does this duty of good faith and fair dealing even come from in contract law? And I guess how broad is it?
So this duty is, it's non-negotiable. It's a core principle of common law, and it's written down in what lawyers call the Restatement of Contracts.
Okay.
Specifically, it's Section 205, and it just says, every contract imposes upon each party a duty of good faith and fair dealing in its performance and its enforcement.
So every contract, no exceptions.
Every contract. You should think of good faith as like the contract's immune system.
Huh. I like that.
It's what stops one party from using a technicality in the contract to just destroy what the other party was supposed to get out of the deal. And this applies everywhere, including, professional contracts, like for real estate agents trying to get their commission.
So let me make sure I understand this. If I have a duty to act in good faith, how does that actually interact with a condition? I mean, if the contract says I only pay if the closing happens by August 1st and August 1st comes and goes, well, legally it seems like I owe nothing.
Right.
How does good faith force me to pay anyway?
This is where we get the crucial legal idea of an excuse. The law says you can't rely on a condition failing if you're the one who wrongfully caused it to fail.
Okay, so you can't cause the problem and then benefit from it.
Exactly. The formal rule is in the restatement, Section 225, comment B, and it says the non-occurrence of a condition is excused when it's prevented or hindered by a breach of the duty of good faith and fair dealing.
Let me try a non-legal analogy here just to make sure this really sticks. Yeah. Say a contract promises me a bonus if I finish a marathon. That's the condition.
Simple enough.
But on the morning of the race, my boss steals my running shoes and, I don't know, locks me in a closet.
A bit extreme, but okay.
They can't then turn around and say, well, you didn't finish the marathon, so no bonus, right?
that's
Because they prevented it. Is that the idea of an excused non-occurrence?
That is precisely the essence. The key word, though, is wrongful. The prevention has to violate that duty of good faith. You're allowed to rely on the terms of your deal, but you're not allowed to actively, manipulate events just to get out of your obligation.
That sounds like a pretty high bar to clear. I mean, proving bad faith has to be difficult. Okay, let's unpack this with Cantrell-Waind and Associates v. Guillaume Motorsports.
Let's do it.
We have the broker suing the seller for a commission. Let's really analyze this step by step. First, what are the legally dispositive facts? What really matters here?
Okay, so the essential facts are all focused on a deadline. The seller, Guillaume Motorsports, signed a contract with the broker, Cantrell-Waind. It laid out a $15,200 commission.
A pretty standard deal so far.
Right. But the payment was contingent on a critical condition precedent. The closing of the property sale had to happen within 2 years of the contract date. That meant before August 1st, 1996.
And as that deadline approached, what happened?
So the buyer had their financing all lined up by mid-July. Plenty of time. But Todd Williams, Guillaume's president, he started taking some very questionable steps.
Like what?
First, he went directly to the buyer and offered him half of the commission, that's $7,600, if the buyer would just agree to delay the closing until after August 1st.
Wow. So he tried to pay the buyer to intentionally blow the deadline? That's a pretty striking fact.
It's incredibly damning evidence. The buyer, Mr. Bauer, said no. So then, when the buyer's lawyer tried to set up a closing in July, Williams allegedly said he'd be out of the country and just couldn't sign anything until after August 1st.
And he wouldn't use a power of attorney or anything like that.
Refused. Said he was just unavailable.
We know from the court records that he wasn't actually out of the country.
Right. Correct. Discovery showed he was right there in Bentonville for several days during that key window, from July 22nd to the 25th. So the closing got pushed to August 14th, and Guillaume refused to pay the commission.
Okay, with a set of facts that's suspicious, what was the specific legal issue the Court of Appeals had to resolve?
The issue was whether the lower court made a mistake by granting summary judgment to the seller.
Meaning throwing the case out.
Right. The real question was, are there genuine issues of material fact about whether Guillaume breached its duty of good faith by deliberately hindering the closing? And if so, would that breach excuse the condition?
What rule of law did the appeals court then apply to figure this all out? Can you state the full black-letter rule and break it down for us into its testable elements?
Absolutely. The controlling rule is what we've been discussing. The non-occurrence of a condition precedent is excused if the occurrence is prevented or hindered by the other party's breach of the duty of good faith and fair dealing.
It's the you cheated, so the condition is waived rule.
That's a good way to put it. And based on how the court analyzed it, we can break this rule down into 3 functional elements you have to prove.
Okay.
First, there must be a condition precedent. Second, there has to be an affirmative act of the obligor, the person who owes the duty. And third, that act has to amount to wrongful prevention or hindrance.
Thank you. Now for the court's elemental analysis. Let's walk through this piece by piece. How did the court apply that first element, condition precedent?
This was the easy part for the court. The condition was, crystal clear in the contract. Payment of the commission was expressly tied to the closing happening before August 1st, 1996.
No ambiguity there.
None. Since the closing happened on August 14th, the condition failed. So unless it was excused, the duty to pay the commission never even arose. That element was clearly satisfied.
Understood. The condition was clear. Now, what about the second element, the affirmative act of the obligor? What specific actions did Williams take that made this more than just, dragging his feet?
The court looked for activity, not just passivity, and they found 3 distinct affirmative acts in the testimony.
Okay, what were they?
First, that documented attempt to bribe the buyer to delay the $7,600 offer. Second, the alleged lie that he was out of the country. And third, his flat-out refusal to authorize a power of attorney. These were all active choices he made to manipulate the timing.
And this is where we get to the real legal heart of it. How did the court handle the third element, wrongful prevention hindrance? Because the seller's defense seems sort of logical in a hardball business sense.
He does.
They basically said, look, we had a deadline, we didn't breach our contract with the buyer, we just played hardball to save some money.
Why did the appeals court reject that argument?
Because that argument completely ignores the duty of good faith. The seller's lawyer literally argued they had every right to do anything within his power, short of breaching his contract with this buyer.
Which sounds plausible. But the appeals court said, no, that view misses the point. There's this other duty that binds you, the duty of good faith. The court held that this duty obligated the seller to not deliberately avoid closing before the deadline.
So it's the deliberate intent that makes it wrongful.
Precisely. The attempted bribe, the alleged misrepresentations. It all showed Williams wasn't just relying on the contract's terms. He was actively wrongfully maneuvering to defeat the condition for one reason, to save 15 grand. That deliberate intent is what transformed a missed deadline into an excused condition.
That distinction is so important. So if a party is just slow, maybe takes a normal amount of time to get back to someone, that might not be bad faith.
Probably not.
But offering a bribe or lying about your location, that crosses a line into deliberate hindrance.
That's it, exactly. Deliberate avoidance active, deceptive behavior aimed only at contractual defeat. That is the hallmark of wrongful prevention. The policy is clear. The law just can't reward that kind of manipulation.
And after analyzing all 3 elements, the clear condition, the affirmative acts, and the wrongfulness, what was the court's final conclusion?
The court reversed and remanded the summary judgment.
So they sent it back to the lower court.
Yes. They said the trial judge failed to apply the correct law, this duty of good faith. And, crucially, they found that Williams's conflicting stories in his affidavit and his deposition, well, they left genuine issues of material fact.
A jury needed to decide what his intent really was.
Exactly. A jury had to decide if he was deliberately and wrongfully hindering the deal. and the court made it clear. If the jury finds he did, the commission is owed, regardless of the August 1st date.
Okay, let's test this with a hypothetical to really understand the line. In the real case, Williams lied about being out of the country.
Right.
What if Williams was, say, a neurosurgeon, and he had a non-negotiable emergency surgery scheduled abroad that started on July 28th, and he just refused to cancel it, knowing it would push the closing past the deadline? Is that still wrongful prevention?
That's a great hypothetical because it really tests the boundary of good faith. In that scenario, it might not be wrongful.
Why not?
Because the duty of good faith doesn't require you to sacrifice your legitimate pre-existing business or personal interests just to make sure a condition is met. Good faith is breached when the primary deliberate purpose of your action is to defeat the condition.
So the surgeon's trip has a legitimate purpose.
A very legitimate one. It's not a lie or a bribe made up just for contractual sabotage. The line is crossed when the action has no real purpose other than to blow up the deal.
That makes the real facts of Cantrell-Waind even more powerful. It was the deceit that proved the lack of a legitimate purpose.
Exactly right. The case just confirms that contracts are built on an underlying promise of integrity.
We've broken down how this all works through the lens of Cantrell-Waind. For the listener who's, tackling this on an exam or in practice, how should they approach the analysis? Can you give us a step-by-step checklist?
Of course. To spot and analyze this issue effectively, you need to follow this structured path. Think of it as your final synthesis of today's deep dive.
Okay.
1. Identify the conditional obligation. First, what's the duty at stake? The payment, the performance, and what is the exact condition that triggers it?
Step 2.
Identify the non-occurrence.
Okay.
Simple enough. Did the condition fail? Did the deadline pass?
Okay, 3.
Scrutinize the oligarch's conduct. This is key. Did the party who benefits from the failure take any active affirmative steps to interfere? You're looking for deceit, misrepresentation, bribery. Was it active sabotage or just passive inaction?
And finally,
Apply the wrongful intent test. If there was interference, you have to ask the critical question. Was the action taken with the express, deliberate intent to avoid the obligation? If it lacks any other legitimate purpose, then it's wrongful hindrance. And your conclusion, if you find wrongful hindrance, is that the condition is excused and the duty is now due.
that's a fantastic diagnostic tool. It really clarifies the path. It shows that while a condition precedent is like a shield, the duty of good faith is the sword that can cut right through it.
That's a great way to put it. The legal system really demands fairness in performance. Cantrell-Waind is just an unforgettable reminder that the letter of the law can be overridden by the spirit of the law.
Here's a final thought for you to mull on. What if the seller, Williams, had just gone silent, ignored all the calls, didn't lie about being out of the country, just waited until August 2nd to pop back up? Would that earlier attempt to bribe the buyer still be enough to prove wrongful prevention, even if his later conduct was just passive? It really speaks to the lasting effect of an initial bad act. That concludes our deep dive into excusing conditions. We hope this framework helps you navigate the complex relationship between a contract's text and its spirit. We'll see you next time.